to go. All right. So we're ready to proceed. As you know, you're given 20 minutes and up to 5 minutes for rebuttal time, ma'am. How much time do you need?
I would like 5 minutes, please. Thank you.
Very good, ma'am. You may proceed.
Good morning, and may it please the court. Kelsey Hazard on behalf of petitioner Joseph Baird. In Gundel versus AV Homes, this court held that certiorari is appropriate to protect the substantive right recognized by Florida's anti-SLAPP statute. A defendant's right to be free from a strategic lawsuit against public participation and all of the time and expense and aggravation that a SLAPP entails must not be rendered illusory. This court rightly expressed concern about decisions that frustrate the purpose of the statute such that the statutory protection becomes essentially meaningless for the defendant. The trial court in this case rendered the statutory protection essentially meaningless for Joseph Baird. And it did so in a few ways. Most critical.
And before you begin, Ms. Hazard, I guess the first initial point for us is, first of all, do we have jurisdiction? And when I say do we have jurisdiction, this is a cert standard. And so under the cert standard, as you know, we need to make it's a two-pronged step. And you've mentioned Gundel as one of the cases that you relied on, but isn't Gundel a little bit different? Because in that case, the court really didn't follow the proper procedure. From my recollection of that case, the parties filed a motion to dismiss, motion for summary judgment. The court did not even allow them to even deal with, to even hear the summary judgment. Unlike this case, as I see from the record, the court did follow the appropriate procedure. So why do we have jurisdiction in this case?
Your Honor, Gundel, you're correct that the procedural posture of Gundel was a bit different, but the court recognized that the source of the irreparable harm was not merely the failure to follow the procedure, but the fact that the defendant was going to be subject to this continuing litigation that was that the Florida legislature has made very clear as a matter of public policy should not continue to go forward, that the very existence of the continuing litigation causes irreparable harm to the defendant.
Because as I understand, the whole purpose of the anti-SLAPP is right away, if you state a cause of action, if someone exercises their right for free speech, and if they're sued wrongfully, then immediately you want to bring it before the trier of fact to determine, wait a minute, is that under my protected speech? And if it is, dismiss or grant summary judgment or do anything to be freed from this. I think we all agree on that. So I guess my question to you is that in this case, the court immediately went through, there was a motion for summary judgment, the court considered all the affidavits, came to the conclusion, sorry, you failed to meet your burden to prove that you've exercised your First Amendment rights. So the way that you're arguing is that, yes, the court may have filed the proper procedure, but came to the incorrect result. If that's the case, is that appropriate for cert?
Well, Your Honor, when we the proper procedure, I would argue, was not followed. There were several points of error identified in our brief. One issue, Your Honor, is that the incorrect standards were applied by the court in the consideration of the summary judgment motion.
And walk me through that. What exactly is your position for that?
Yes, Your Honor. The Supreme Court of Florida in Nodar versus Galbraith put forward a very on-point opinion, which the trial court in this case failed to apply. The analysis of common law privilege and express malice that's required by Nodar is completely absent from the trial court's order. And had the trial court properly undertaken that analysis, it would have found that Mr. Baird's statements were privileged as a matter of law, and that Mason Classical Academy lacked sufficient evidence of express malice to overcome that privilege. MCA's case is therefore without merit under the terms of the anti-SLAPP statute, and its claim was therefore subject to dismissal. And the facts of Nodar are quite similar to the facts of this case. Mr. Nodar made statements to the school board, to his son's teacher and her superiors, to members of the public who were in attendance at that school board meeting. And Mr. Nodar alleged that the plaintiff had harassed and victimized his son. That was his statement.
Isn't NODAR different in that it was only the government entity and on kind of one occasion, as opposed to multiple occasions, and you have social media posts and that sort of thing. So isn't there some real factual distinctions between the two of them?
Well, Your Honor, while there's no perfectly identical fact pattern, I think NODAR comes pretty close. And the anti-SLAPP statute prohibits suits that are brought primarily because the defendant exercised the constitutional right of free speech in connection with a public issue. That word primarily.
Right, and that's what I would like you to address is, I mean, you've got separate correspondence to Hillsdale and the social media post in addition to the complaint filed with the Florida Department of Education. So doesn't this go way beyond, isn't it more broad, such that the trial court could look at that issue and make a determination on whether summary judgment was appropriate or whether that needs to go down the path a little further?
So I have two responses to that, Your Honor. The first is that anti-SLAPP protection is not limited to speech made exclusively to government actors. Again, that word primarily is very important. After all, communications with government actors are typically public record that can be heard or read by anyone, but that does not strip them of protection under the anti-SLAPP statute. And the record does not reflect any communication to Hillsdale College that had not already been shared with the proper educational authorities. On page 371 of the appendix, Your Honors will note that Mr. Baird's email to Hillsdale, it actually begins, "I wish to share with you a comprehensive report detailing all of the allegations regarding Mason Classical Academy that I have reported to John Fishbane of Collier County Public Schools." And he even copied Mrs. Kelly Lichter, the MCA board president, on that email. So there really isn't a distinct body of allegations or statements that were made to Hillsdale that weren't already part of the public record through his rightful petitioning of the government.
But to follow that thread, some of his, I mean, he's taking the issue that his speech falls within the statute, but the fact that the statement that he made on Facebook to other parents, there's other stuff that was put in there. So how can he make a showing? Because based on the statute, here's what it says. It says that primarily that the speech must be made before a governmental entity, and the lawsuit must be filed without merit and filed primarily due to the exercise of constitutional speech. And in this case, he went kind of beyond. And to follow up with what Judge Sturgill said, we're talking about Facebook, we're talking about other parents, we're talking about other things that will take it away, not simply the governmental. How do you respond to that?
And Your Honor, those extraneous allegations really are only came up in Kelly Lichter's affidavit in response to the motion. We argue that the trial court should not have allowed MCA to change its theory of the case for purposes of defending the motion.
Isn't one of the things that you have to show that it's primarily that it was done to protect his constitutional right, primarily? So doesn't the other side have a right to show, wait a minute, this was not done primarily because he not just simply for governmental, he basically included a whole bunch of other people. Doesn't that kind of undermine that prong?
Well, Your Honor, that's not the theory of the case that MCA has pled. MCA completely pivoted to the extent that the trial court's order relies exclusively on statements by Mr. Baird that were not pled. And yet the pleadings in this case continue to be based on a theory that MCA was damaged by Mr. Baird's statements to the Florida Department of Education and John Fishbane. So we have this situation, Gundel states, a plaintiff should not be able to thwart the purpose of the anti-SLAPP statute by being vague in its pleadings. And unfortunately, that's exactly what happened here.
I guess I'm a little bit confused because I'm looking at the record here. Baird mentioned some of these in his motion to dismiss before MCA filed the response. So I think you may be mistaken that MCA injected all of this post-complaint.
Well, Your Honor, the specific allegations that came up for the first time in Ms. Lichter's affidavit, there were some general statements in the pleadings about that Baird was lobbying the government and encouraged others to lobby with him. That general language is there. But the allegations that he was, all of this, the what's wrong with MCA document, the rebuttal to Sean Arnold, all of those types of social media things, that really did not come up in the pleadings. That originates with Kelly Lichter's affidavit and attachments. Your Honor, I'd like to add that the trial court also erred when it found that Mr. Baird had not made a prima facie case for application of the anti-SLAPP statute. The trial court's ruling that Mr. Baird didn't allege that his statements were true and without malice is simply incorrect. The motion may not have used the magic words that the trial court would have preferred, but it was sufficient to apply the anti-SLAPP statute and shift the burden to MCA. The trial court also erred to the extent that it only required MCA to show the existence of disputed issues of fact. Gundel imposes a higher bar. MCA had the burden to demonstrate that its claims are not primarily based on First Amendment rights in connection with a public issue and not without merit. So application of the traditional scintilla of evidence summary judgment standard is inappropriate for much the same reasons that the application of the typical motion to dismiss standard was found inappropriate in Gundel. The anti-SLAPP statute does require the trial court to do more. Excuse me, Your Honor. I want to talk for a little bit about Hirschhalla versus Lake Point Phase 1, which MCA relies upon to argue that false representations demonstrate express malice under a wrongful means theory. With due respect to the 4th District Court of Appeal, the Hirschhalla approach is problematic for a few reasons. First, Hirschhalla's approach collides with the Florida Supreme Court decision in Nodar. Mr. Nodar's statements were ruled defamatory, but nevertheless protected because they were not made with express malice. The express malice standard is that the statements can only be actionable if the speaker's primary motive was an intention to injure the plaintiff. That's the express malice standard. It is a difficult standard to meet. If a statement's falsity were proof of express malice, then Nodar logically would have had the opposite outcome. The second problem with Hirschhalla is it causes that express malice standard to encompass the actual malice standard, which is that the speaker knew the statement was false or acted with disregard of its truth or falsity. That blurs the line between what are supposed to be two distinct tests. Third, Hirschhalla relied on a dissenting opinion for the premise that false representations are wrongful means. And fourth and finally, that discussion in Hirschhalla is dicta because the Hirschhalla court did not have to reach the question of whether false statements demonstrated express malice. It also had found that express malice was present under the correct Nodar standards, that the defendant was motivated primarily by a desire to harm. So MCA had the burden to come forward with evidence of Mr. Baird's express malice under Nodar that would take him outside the protection of the common law privilege and the anti-SLAPP statute. Mr. Baird's accusations alone are not enough, even if they had been false. A tendency to become combative is not enough. A disagreement about athletic policy is not enough. Mr. Baird, like Mr. Nodar, is entitled to a presumption of good faith. That's true even if he did not get along with MCA leaders. We certainly know that he did not, but nevertheless, he is entitled to a presumption of good faith. That's especially true because in this case, the general counsel of the Collier County School Board, John Fishbane, has already investigated Mr. Baird's complaint to the Florida Department of Education and determined that it was well-founded. I recognize that this presents a matter of first impression, but the trial court's failure to even acknowledge the existence of the Fishbane report is very troubling.
Ms. Hazard, just to let you know, you're about to get into your rebuttal time. Feel free to go forward, but I just want to let you know, okay?
All right. Certainly the failure to acknowledge the Fishbane report goes against the spirit of the anti-SLAPP statute. MCA has sued Mr. Baird not only to punish him for his speech, but to punish him for the fact that the government has agreed with his speech. So with that, Your Honor, I reserve the remainder of my time for rebuttal.
Very good, ma'am. Thank you, Ms. Hazard. I'm going to ask you this time to mute yourself while we, oh good, Mr. Brannick, you unmuted yourself. All right, Mr. Brannick, you may proceed, sir, with your argument.
Good morning, Your Honors. May it please the court, I'm Steve Brannick of Brannick, Humphreys, and Berman, here representing the respondent Mason Classical Academy. In assessing this petition for certiorari, it's important to understand what the anti-SLAPP statute does and does not do. First, it does not change the underlying substantive law. That is, it doesn't change the standard of what it takes to plead and prove a tortious interference claim. Secondly, it doesn't change the well-settled standards in assessing a motion to dismiss or a motion for summary judgment. And as I will discuss in my argument, we easily demonstrated to the trial court that we pled a tortious interference claim and also brought forth the evidence that would survive summary judgment in the tortious interference context when there are claims made of privilege. What the statute does do is provide an early look. It gives the defendant the right to compel the defendant to prove that they can plead a cause of action and that they have evidence to back up that cause of action. That's exactly what they got here. They got that early look. The parties submitted substantial evidence. The trial judge analyzed that evidence, decided that Mason Classical Academy had in fact pled a cause of action and had in fact submitted the facts necessary to demonstrate that it could prove a tortious interference claim and overcome the privilege here. So this is very much unlike the Gundel case. The Gundel case, this court granted cert because the trial court simply did not apply the protections of the statute. The trial court refused to look at the evidence and to decide the case under the summary judgment standard. This court then granted certiorari. In this case, they got all of the.
Okay, let me ask you a question, Mr. Brannick. If a complaint alleges both speech that is protected under the statute and speech that is not, what is really the appropriate remedy? Because in this case, they allege that their client's speech was protected. And it's true if it's done to governmental agencies or any governmental entity. But in this case, there's also brought out the fact that Facebook, other parents, other things that would not be protected. So if a complaint alleges both, is that what deference do we defer to the trial court's conclusion that this suit is not, because it's not primarily based on this exercise of protected speech, because it has reached out to other people? What is the remedy?
We think they're entitled to protection under the anti-SLAPP statute only if they can show that all the speech is protected. Certainly as to Hillsdale College, that's not a governmental entity. They submitted not only the same information that they submitted to the district, but also their what we've called their manifesto, their very extensive Facebook complaint that goes far beyond those complaints. So as to Hillsdale, they're clearly beyond the statute. As to the government, we think they're beyond the statute because their claim is, because our claim is not without merit and because their speech is not protected because it was done with express malice. So it is clear in this case that both claims should survive and that we should go forward. The jury ultimately will determine the truth and falsity of the various allegations that are brought by the parties. So they got their early look. And the trial court said, no, you've satisfied your burden, and summary judgment should be denied. So we don't think as a threshold matter that certiorari is even appropriate here, because really all they're asking this court is to second guess the trial court's determination on summary judgment. And as we all know, certiorari is not appropriate to review a trial court's decision to deny summary judgment. So if certiorari may have been appropriate in Gundel, of course, the Fourth District has disagreed in the WBP case, but even if we put the Fourth District Court of Appeal decision aside, in Gundel, we were in the heart of certiorari because the court didn't apply the statute. Here, the court did apply the statute. We don't think certiorari is appropriate in this case. But assuming the court is going to go to the merits, the statute tells us that the question before the court is whether the speech is protected under applicable law and whether the lawsuit is without merit. Mr. Baird loses here because his speech was not protected and the lawsuit does have merit. The Florida Supreme Court in the Londano case and the Fourth District and the Fifth District in the Herchala and the Fern Growers case, all applying the Nodar case, which of course is the granddaddy case about express privilege. But those three cases all apply Nodar in the context of a tortious interference action, and they tell us exactly what the law is. Sure, their claim may be subject to a qualified privilege because it was in part, at least in part, related to a complaint to the government. But that qualified privilege can be overcome if express malice is proven. Those cases tell us how you prove express malice. Either one, if the purpose is primarily malicious as opposed to constructive, or two, if the defendant uses improper means such as deliberate fraud or deliberately false statements. Now, we're not saying in this case that just the fact that the statements are false is enough to prove in and of itself express malice. It's the fact that those statements were deliberate falsehoods. They were knowing falsehoods. And the Fern Growers case and the Herchala case both tell us that those are the sorts of statements that do qualify express malice. So let me just look at the evidence real quickly. First, in terms of the evidence that the primary intent here was malicious. The complaint that was brought by Mr. Baird came on the heels of his argument over his kids' participation in the organized sports programs at MCA. The jury could well ask itself, why did he keep his complaints to himself for so long when he was on the board and still active at the school? And why did he raise them only after he became angry, particularly when he admits in a letter to the school that oftentimes he has a terrible tendency to become combative when he's crossed? And the jury might also ask, why did he make these, why after he made the very glowing statements about the principal in this of MCA, about how there's no one else he would more highly trust his kids to. I think the jury could well ask himself, why in 1 month is the principal also highly trusted, and then just a few months later in this report, suddenly so very nefarious. Then the jury might well ask itself, why didn't he raise these complaints internally first? Why did he go directly to the state and then to the district? And then look at the tone of the criticism, particularly in what we've called the manifesto. He uses very strident language that goes very far beyond what he needed to do to make his point. He talks about destruction of public records with intent to cover up. He talks about falsification of documents with intent to cover up the cover-up. He talks about illegal board meetings. He talks about use of grotesque language. He talks about a culture of fear. He talks about staff members being terrified, heart-wrenching stories of maltreatment, fear of retaliation, and he even says that his daughter was diagnosed with PTSD arising from trauma sustained during the time at MCA. These are the sort of very strident statements that, although in and of themselves are not express malice, certainly are evidence of express malice. So you put that all together, and I think the trial judge was absolutely correct to say that there was enough here for a jury to sort this out at the end of discovery and at the end of the case. Then there's also evidence of knowing falsity. Chair Kelly Lichter filed an extensive affidavit that addressed all of Baird's allegations and explained why those allegations were false. She shows that he was given access to the records necessary for his job, denied the claim that they had blocked efforts to form the financial Oversight Committee and showed in the record exactly why, denied the claims that Principal Hull was not subject to oversight, denied the claims of sunshine violations. She was joined in those denials by another board member, Mr. Steer. So there was lots of evidence submitted that Mr. Baird made these statements knowing that they were false. So again, the trial judge correctly determined that at least for purposes of surviving summary judgment, express malice had been proven. That was so that is all that they were entitled to under the anti-SLAPP statute. They got that. They got that early look. We submitted the evidence that was necessary to overcome the qualified privilege, and that should be the end of this. The only other point that I want to address is this allegation that the complaint was not sufficient. A complaint need only be a short, plain statement of facts. You don't have to marshal all of your evidence in a complaint. Our complaint was actually quite detailed. It anticipated that they would be asserting that there was a privilege here. And so it added allegations showing that there was evidence of express malice and provided 3 examples. It provided the example of the board oversight controversy, the financial oversight committee controversy, and the Public Records Act. We don't have to, in a complaint, put all of our evidence in. We don't have to show all of the examples. We didn't have to show any examples.
Well, that's all I wanted to ask you with that, Mr. Brown. So it's your position that the complaint did not need to set forth statements made in Facebook to other parents, to other things, that really was not is not appropriate on when you're dealing with filing of a complaint. Is that?
Yeah, those are just all evidentiary facts that would support the allegations in the complaint. Just like in an auto accident case, all you have to do is allege negligence. You don't have to detail exactly what the negligence was, what the driver did wrong, what the pedestrian did wrong. None of that goes into the complaint. That's all part of the development of the facts, the discovery, and ultimately the summary judgment if there's an argument that the facts are not sufficient. But we did in fact allege that these statements were made with express malice, that his intent was malicious, and that the statements were deliberately false, and provided 3 examples of that. That's all we needed to do. In fact, I don't think we needed to provide a single example. We certainly didn't have to provide all the examples, and there's nothing in the statute that says that that if the court is considering the evidence on summary judgment, for example, you are limited only to the examples that you include in your complaint. So for all those reasons, we think the trial judge did exactly what the statute required. Found that there was in fact evidence of express malice, and therefore we think that the petition for writ should be denied.
Thank you, Mr. Brannick. All right, Ms. Hazard, I have you as having 4 minutes for rebuttal, ma'am. So whenever you're ready, please proceed.
Thank you, Your Honor. We are not here to second guess the trial court's view of the merits. We are here because the trial court did not use the proper standards in evaluating the evidence that had been put forward. The trial court, again, failed to even cite NODAR, failed to go through that analysis in any way in its order. Regarding the appropriate remedy for this sort of mixed bag of statements where some were made to the government and some were made to private entities, we think that they are connected enough that the primary allegation is the exercise of First Amendment rights under the SLAPP statute, and that it's all subject to dismissal. But certainly failing that, we would welcome a remand from the court that would give the trial court some guidance on how to separate that out and the appropriate standards to be used. I would also note that with regard to the mechanics of the anti-SLAPP statute, we do have this unfortunate issue that hasn't been fully fleshed out this morning, where it appears that the trial court faulted Mr. Baird, gave some weight to the fact that Mr. Baird hadn't filed some sort of counter rebuttal affidavit after Ms. Lichter and Mr. Steer filed theirs. And Your Honor, to hold that against Mr. Baird is a miscarriage of justice, because the statute simply never afforded him the opportunity to do that. The statute doesn't have any provision for that, and the deadline had passed for him to do that under the court's prior order. So for the court to suggest that Mr. Baird's failure to submit an affidavit of rebuttal is a reason to deny the motion, that indicates a procedural problem that should be remedied with certiorari. I'd like to pick up on the negligence analogy that opposing counsel shared. This is not, if you were to imagine a complaint in which there's a negligence claim and the complaint says negligence arose because the driver was distracted by his radio, fiddling with the radio instead of paying attention to the road. And then on a pre-trial motion, suddenly the plaintiff says, oh, actually, our primary allegation is that he was negligent because he was under the influence. That's the type of shift that occurred here, where they gave examples in their complaint, and then at the argument on the hearing, opposing counsel said, well, actually, primarily our suit is based on these false statements that are highlighted in Mrs. Lichter's affidavit. That's the type of pivot that occurred here, and which apparently occurred only for purposes of the motion, because the complaint was subsequently amended and didn't change anything about the allegations of false statements.
Actually, Ms. Hazard, you have about, a few seconds left if you want to wrap it up, please.
I don't think I can make any further arguments in that short of a time, but thank you very much and have a wonderful day.
Thank you, and really a well-argued, very interesting case. Well done on both sides.
It is.
Thank you. Thank you both. Thank you. All right. So the next case that the court will be calling is the case of PDK Unlimited versus Wilmington Savings Fund Society.